You just got laid off. Your income went to zero, but your child support bill is still hundreds, if not thousands of dollars a month. What do? Child support does not pause automatically. If you do not act immediately, you will drown in debt and you could lose your driver's license. So in this video, we're going to be exploring just that, as well as to address the retroactive rule, proving a material change in circumstances, the danger of earning capacity, as well as verbal agreements to reduce your monthly child support obligations. Hi, I'm Sina Mohajer with Mohajer Law Firm. We specialize in family law, estate planning, criminal defense, and personal injuries. In these videos, I like to take complex issues and try to simplify it in order for you to understand your rights and be able to make an informed decision about your own case. So if the contents of this video is helpful to you, hit that like button and don't forget to subscribe so you're always informed of any new videos being posted. Without further ado, welcome to our mini-series called A Walk in the Park. So what is this retroactive rule? Well, in California, judges can only modify child support back to the date you filed the paperwork, not the date that you lost your job. So if you lose your job, let's say in January, but you wait until June to tell the court, you will still owe the full monthly obligation for February, March, April, and May. So it is very important, once your circumstances change, you immediately file your paperwork in order to preserve the date of retroactivity for the court to modify your obligation to the date closest to when those circumstances have changed. However, in order to change an order, especially after judgment is entered, you must prove a material change in circumstance. A job loss, a massive pay cut, or even medical disability would qualify. However, you must prove the job loss was involuntary. For example, you were laid off or even fired, not that you just quit to avoid paying. So be sure to keep your termination letter, severance package details, and proof that you are actively applying for new jobs. If the other parent thinks you are intentionally staying unemployed to lower child support, they can technically ask the judge to impute income to you. This means the judge will calculate your child support based on what you could be earning rather than what you're actually making, which is $0. In this situation, you must prove to the judge that you are making a good faith effort to find work in order for the court to not impute your earning capacity for purposes of calculating child support. But let's say you and your ex have verbally agreed to lower the amount of child support that was previously ordered by the court. Well, first off, never rely on a verbal agreement or even a text message from your ex saying, "Don't worry about paying this month since you lost your job." Verbal agreements do not change a court order. The Department of Child Support Services, as well as the family court, will still track the arrears, and your ex can change their mind later and demand the back pay plus 10% interest. So every agreement needs to be put into writing in the form of a stipulation. That stipulation is then filed with the court for the judge's signature in order for you to not get the short end of the stick and owe back pay plus interest. So to recap, if your income drops, you must file a request for order to modify child support immediately. Every day you wait is another day of debt you can never erase. If you find yourself in a similar situation or have questions about your case, I welcome you to contact us to schedule a consultation. I would be happy to sit with you one-on-one and explore what remedies are available to you and the best strategy to take. And as I stated in the beginning of this video, if the contents here were helpful to you, hit that like button and don't forget to subscribe either, so you're always informed of any new videos being posted.